Welcome back, everyone, to the employment space. This channel is designed to provide to you a 360-degree view of the employment relationship. This channel is for employers, employees, independent contractors, vendors, employment attorneys, and HR professionals. Now, we have finally made it midway to the Federal Employment Law series. So much good information has been provided in each post. We started with the Fair Labor Standards Act, and FLSA is probably the most commonly misunderstood federal employment law by U.S. employers. Then we moved on to what's known as the Workplace Discrimination Law, which is Title VII of the Civil Rights Act of 1964. And while Title VII is known to be a foundational employment law to the United States, it's also the most litigated. Then we moved on to the Americans with Disabilities Act, and this particular federal law creates a great deal of risk for employers due to failure to follow process. And then we moved on to the Family and Medical Leave Act, which is not a very complicated law, but it is very easy to mishandle. In this post, I bring you the Age Discrimination Employment Act. And, this particular Federal Employment Law Act becomes especially important during times of different times of the employment relationship, such as hiring, firing, performance management, restructuring, layoffs, and many other places within the employment relationship. So today I'm bringing you the 5 things employers should know about the Age Discrimination Employment Act. Let's get into it. Number 1 is actually going to have 2 parts. 1A, are you a covered employer? And 1B, what does this law protect? If you are a private employer that has at least 20 employees, then you are a covered employer under the ADEA. Under 1B, what does the law protect? Well, it provides protections to both applicants and employees who are at least 40 years of age. If your organization is an aging workforce, or if you're thinking about restructuring or reduction in force, then ADEA compliance should be on your radar. Moving on to number 2, and that is the ADEA isn't just about termination. The ADEA prohibits discrimination in all aspects of employment. So that means from applicants all the way through to the termination of an employment. Now, another thing is that be very careful as an employer, for informational purposes only, from my experience with drafting policies and practices, you have to be very careful with how you draft the language of the policies, because sometimes the policies can appear on their face as though they're facially neutral, but in fact have a disproportionate impact, a very negative or even discriminatory impact on members of your workforce or even prospective talent who are at least 40 years of age. Make sure you consult with an experienced employment attorney before releasing any of your policies. Moving on to number 3, watch what you say. The best way that your management and leadership within your organization, and actually all employees, can make sure that they all remain in compliance with the ADEA is through the proper training. Watching what you say in conversation with any employee is important, whether they are 40 years of age, older, or younger than 40 years of age. Okay, so the proper training can really kind of go through the do's and don'ts of what to say during a conversation. There are times when something can be said, and it doesn't necessarily mean that that's going to result in a successful, whatever was said, will result in a successful lawsuit for an employee. And sometimes what was said can become the heartbeat of litigation. So overall, the training should be focused on the proper conversations, as well as reinforcing to your employees, especially your leadership, that they should be focusing on performance metrics instead of generational stereotypes. Moving on to number 4, and that is layoffs and reductions in force require extra care. Workforce reductions, position eliminations, workplace restructuring, and layoffs all of those are definitely considered by the ADA as high risk. That is because once those decisions are made, a layoff or a reduction in force or restructuring, position eliminations can sometimes have a disproportionate impact on certain members of a protected class. And that's why you should be consulting with an experienced employment counsel, because your counsel should be trained to really run a magnifying glass throughout your workforce to make sure that there is no disparate impact or disparate treatment by those decisions. Additionally, if as an organization, for example, you're doing a layoff and you are going to be offering a severance agreement, then your counsel should also be knowledgeable about including certain language that protects individuals of a certain age, making sure that your severance agreements basically are compliant, okay? Moving on to number 5, and that is retaliation is a serious risk under the ADEA. Under the ADEA, it has a separate statute that addresses how employers are supposed to refrain from taking adverse employment actions against the workforce. I can tell you as a former litigator that a discrimination claim has different elements to prove up than does a retaliation claim. That's why it's possible for an employer to have a defensible claim in one, and maybe that's not the case with the other, or both are defensible, or neither is defensible, right? So before taking any actions toward any employee, it's always the best decision to run these decisions by your employment counsel, okay? So we're coming to a close here about the 5 things that employers should know about the Age Discrimination Employment Act. You know, this particular federal employment law is not just about bias. It's also about making structured decisions, or highlighting that you should be making structured employment decisions that are objective and consistent and defensible. Especially because when you're making such serious business and employment decisions such as reductions in force, position eliminations, restructuring, and layoffs, you know, you want to make sure that you're in compliance with all federal employment laws in conjunction, and you should be working with an experienced attorney, okay, because once it's done, right? So I'm going to end here. I hope this was helpful information. Again, I hope that this information is also providing to you a different view of the employment relationship. If you have any questions, feel free to reach out to me. My email is in the description box below. Remember to like, share, subscribe, and comment. I'll see you the next time.